Welcome, everyone. Thank you all for joining. On behalf of Osgoode and IP Osgoode, a warm welcome as we kick off the IP Osgoode Speak series with today's fantastic event. Now, I'm Professor Giuseppina D'Agostino, and I'm the founder and director of IP Osgoode, which is Osgoode Hall Law School's flagship IP and tech program. Now, if you haven't already done so, I do encourage you to visit iposgoode.ca, which is our fun and exciting, up-to-the-minute website that has everything that is new in here in Canada and around the world. And I should mention that today's event is being blogged on. So on the ipolog.ca, we have Jamie Franks that will be blogging on today's event, so the conversation will continue. And as we just found out, the event is in fact being recorded. So hello to all of you who will be accessing the recorded version. This will be uploaded on the IP Osgoode site. Now, however, I do encourage you not to contain your enthusiasm and to tweet away. So we have here hashtag IPOsSpeaks. So do express your views as you're in for a treat this afternoon. Now, I should mention that today's event wouldn't be possible without the generous support of our founding sponsors. And here I'm very grateful to Castles, Gowlings, and McCarthy's. And of course, our wonderful organizational team with Michelle Lee, who is sitting there at the back at the helm. Hello, Michelle. Just if we could give her a round of applause. So she's IP Osgoode's assistant director, and she's phenomenal and works closely with Mary Barbieri, whose also tireless efforts have made today's event and our entire speaker series and everything in IP Osgoode possible. Now, as many of you know, IP Osgoode aims to inject many more voices to the IP debate, and we aim to do this by really intensifying the learning opportunities for our students. And I see many of you in the room. And this is really what we're about, and also to build bridges with the IP community here in Canada and around the world. And today's is no exception, because we have with us a global force, a leader in the IP community who will be addressing you shortly. Now, we're in a privileged position today. I know myself, he's actually, our guest speaker is from my own DPhil alma mater, so I'm very excited that he joins us today. And quite fitting that we have our very own Professor David Vaver, who will be introducing him momentarily, because they have a thing or two in common. Now, we've asked our speaker to take about 45 minutes, after which we look forward to hearing from you, getting your questions, getting your comments for a vibrant discussion. So it is now my great pleasure to introduce to you Professor David Vaver, who will be introducing our guest speaker today.
Thank you. Well, thank you, Professor D'Agostino. I guess the things we have in common is we're wearing a blue jacket, and the other thing, of course, is if you have any difficulty mistaking us, he's the attractive one. I'm very pleased indeed to be able to welcome to Osgoode Professor Graeme Dinwoodie, who's the Chair of Intellectual Property and Information Technology Law at the University of Oxford and the Director of the Oxford Intellectual Property Research Centre and a Fellow of St Peter's College in Oxford. I can do that from memory because I had one or two things in common with him there as well. In fact, he's my successor at Oxford, and I know that Oxford was absolutely delighted to get rid of me and delighted to get him when the changeover occurred a few years ago. Graeme is, as Peter has said quite rightly, a force in intellectual property internationally. I have his profile here, but I'm on the Oxford site with quite an attractive photograph as well. Much better than the one they took of me, I've got to tell you. But he's a graduate of Glasgow University, got his law at Glasgow, and so of course he has a particular interest in other events occurring today. He then did a master's at Harvard and then his doctorate at Columbia, and then has taught in a number of institutions before going to Oxford. He's been in Cincinnati, Pennsylvania, Chicago, Kent, lots of visiting appointments. He is an extremely prolific writer. In fact, when you look at the amount of stuff he's written, I suspect that there is actually more than one Graeme Dinwoodie, that there are three, two of which are clones, and they're out there at various other times, because he's this Graeme Dinwoodie 1 is here at the moment, but there's a Graeme Dinwoodie 2 in a few minutes will be out there in Chicago, and another few minutes will be out there in Hong Kong, and I'm quite sure that it's just simply impossible for this to occur short of transubstantiation, which perhaps he's invented and that's on the sly, I don't know. In any event, he's written enormously, a lot of case books that he's edited, a lot of articles, a lot of books, all in the intellectual property and interested in particularly international and comparative intellectual property law across the board. And today, of course, he's speaking on a subject which he's written a lot about in various guises, and that's trademarks and the territorial aspects of them. The title, I don't need to repeat the title because it's gone. But it's, as we all know, all of intellectual property now is, you can't talk about national law. If you ever did talk about national law, that was just one facet of it. It is global, international, and the problems, of course, that you have in IP rights that cross boundaries are legion. And Graeme has worked a lot and thought about and written a lot about this particular aspect, about trademarks and the problem of territoriality, the crossing borders, and we look forward very much to hearing what he has to say. Welcome to Osgoode, and we look forward to what you have to say, Graeme. Thank you.
Thank you very much, David, and thank you very much, Pina, for the invitation and the kind words. Indeed, yes, I hold almost exactly the same titles as David held, so it is indeed committed to our memory, and it's wonderful to be able to be here and seeing old friends and talking on a topic that I've thought a lot about, as David said. The project that's under this particular title that I am working on at the moment is a book project that's meant to reach a conclusion 2 months ago, which means it will probably actually be sent to the publisher sometime in early 2015, so I hope OUP are not listening to the recording. But it is a project, however, that grows out of something that I really started thinking about, mostly in an American context, about 10 years ago. And over the last couple of years, I've tried to examine whether the same dynamics that I had identified in American law existed in European law, and that's largely going to be the focus of the comparison that I will engage in today. But many of the same issues exist in trademark laws throughout the world, and one of the perspectives I'd love to get from you is whether some of the features of the system that I'm talking about in the United States and the European Union indeed replicate in Canada, where they corroborate the thesis, maybe they undermine the thesis, maybe they suggest nuances that I need to work into the thesis about territoriality. I've read enough Canadian trademark law just to be dangerous, I suspect, and look forward to being corrected in any and disabused of any notions that I have that are wrong. As David said, it's a cardinal principle of intellectual property, all intellectual property law, that it is territorial. It's been that way even in the international systems since the late 19th century. The Paris Convention in 1883, the Berne Convention in 1886, both, even though they're international treaties, paradoxically installed the principle of territoriality, of national rights, as the foundation of the international system. An international harmonization, which we talk a lot about these days, hasn't really interfered with the purity of the legal proposition that trademarks and IP is territorial. However, global trade, as opposed to just the legal changes, global trade, social changes, and in particular, I would say, an online marketplace, have called into question the practical relevance of the legal principles that trademark law is territorial. There's a growing gap between the global reach of markets on the one hand and the local reach of marks on the other. Trade is actually international, even if trademark law is still resolutely national. And it's the gap between those legal principles on the one hand and the practical realities on the other that commercial actors are concerned about, because it creates costs, it creates uncertainties, and the question is how to respond to that gap between social reality and legal principle. This concern about a gap between law and commerce isn't new. The Paris Convention itself in 1883 was a response to pressures on territoriality caused by cross-border trade in products. And every so often in the 130 years since, you will hear scholars or courts, policymakers saying, the world is a completely different place, we just must adapt this basic principle of territoriality. So one shouldn't suggest that this is completely revolutionary, but I think we are in a slightly different degree of a gap between the commercial reality these days and the legal principle. The question is what to do about it. The same question that people have asked for 130 years. Should we in some ways reconfigure the legal principle of territoriality to comport more with the commercial reality that's out there? Well, 20 years ago now, the European Union adopted what to some people would regard as quite a radical approach to territoriality of trademark rights when it created the CTM, the Community Trademark, which is an attempt in some respects to mitigate the problems or some of the problems of trademark rights and allows European producers, and indeed anyone operating in the European market, to try and adapt their trademark rights from a national basis to a regional basis. And perhaps it may be a model, as I'll talk about in a second, for the same development at the global level. The questions raised by the European experiment, although it's now, I guess, firmly entrenched when we can call it an experiment, are important questions, partly because I think they give us some insights to the nature of trademark law, partly because the European market is a very big market for any large producers, and in fact the main users of the European CTM system are not Europeans, they're non-European producers. But it's also very, very important because the CTM system is increasingly seen as a model for initiatives outside the European Union. So you can go back to 1978, the American Commissioner of Patents and Trademarks at the time, a fellow named Sept was asked to speculate as to what he thought the state of trademark law would be in a century, a year, 100 years' time. And he predicted there would be, and I quote, a supranational world trademark system with a single registration with worldwide effect, unquote. Now, 3 years ago, Ruth Anand, who's a British scholar and a co-author, suggested that the CTM provides the model for such a world trademark system. Though they were skeptical, to be fair, as I am, that the underlying political and social conditions for such a development are going to be in place for quite some time. So I don't think we're going to see a global replication of the CTM with a trademark that you get for 180 countries anytime soon. However, it is being mimicked in a number of intriguing places around the world. So you can find unitary systems very similar to the CTM, either adopted or being considered. For example, among the Russian Commonwealth of Independent States, which is Russia, Belarus, and Kazakhstan, by groupings of African countries, both French-speaking and English-speaking. Australia and New Zealand are considering the possibility of a trans-Tasman mark that would give you rights both in Australia and New Zealand. And then perhaps even most intriguingly, I think, there is a group of Portuguese-speaking countries, of whom there are 7, and prizes for people who can name all 7. I couldn't tell you the 7 until I found the research, who are considering a so-called Lusophone mark, which would be a mark valid in all 7 Portuguese-speaking countries. And what's really interesting about that is it suggests that maybe the essence of trademarks is not so much connected to territory, but actually to culture and language, rather than the geographic proximity. So that's an interesting example, but you can see all of these build to some extent on some of the lessons of the CTM, and I suppose, closer to home at the moment, we could contemplate the possibility of an AFTA mark or a CAFTA mark or something in North America that mimicked it to some extent. So there are lessons, I think, to be drawn from the CTM that may be of direct application, direct relevance, but I think they're also, they say something about the essence of trademarks, and that's what I want to try and explore in the remarks today. Before I lay out the ways in which the CTM has challenged the problem of territorial rights, I want to make a couple of preliminary observations about the principle of territoriality itself, because these are going to help understand the distinctions I draw and the critiques I offer of the European, of the CTM system. And I think they may also help us think a little about the way we might reconfigure the principle of territoriality. So I previously argued, and I just want to summarize to some extent the argument I made 10 years ago, that if you look at statements about trademark territoriality, they in fact mask a variety of related but different propositions. And I want to just quickly recap those. And that is that in fact territoriality is a principle that affects different parts of the trademark system and indeed different parts of the intellectual property system in different ways. So you have territorial philosophies that affect the laws, the rights and enforcement or actions. And let me just elaborate a little bit on that distinction and why I think that actually matters. So first of all, trademark laws. And by trademark laws, I mean basically the norms that are going to govern the question of the availability and the scope of trademark protection. And those laws are largely territorial. They're promulgated by, on the whole, national legislatures, or developed by national courts, although to be fair, increasingly they do so with an eye to international norms. The second set of rules or aspects of the trademark system that are territorial are the trademark rights are territorial. That's to say they're acquired. Rights are acquired on a territorial basis. Territoriality requires a producer to go around and get trademark rights for every country in which they seek protection. In many countries, the United States remains the paradigm, but this was true historically in Canada and the United Kingdom as well, that use is required in order to obtain protection, which may be a touchy issue, I guess, in Canada right now. But outside the United States, in many countries in the world, the rights are acquired simply by making a separate application to the trademark registry. Eventually you have to use normally within 5 years, but you have to do that on a country-by-country basis historically. And in every single country you have to make sure you don't have a conflict with any one of the local marks. So trademark rights are also acquired and subsist on a national basis. And then finally, enforcement mechanisms are territorial. So a German trademark gets you only protection within Germany. Extraterritorial relief based upon a national mark is an exception that national courts only consider in a very limited range of circumstances. And interestingly, and perhaps something that not all intellectual property lawyers engage with, unlike causes of action for, say, contract or tort or delict, any trademark infringement action normally has to be brought in the country in which the rights subsist. That is to say, the general rule throughout the world is that an action for infringement of, let's say, a French trademark has to be brought in a French court. This is different from copyright these days, actually, and it's certainly different from a lot of private law causes of action, such as contract or tort. So, as a result, there are different sets of rules that have a territorial component. So what's the value of trying to separate them out as I have just done? Well, for one thing, you see that different aspects of the territorial proposition create different problems, and those different problems require different types of solutions. So territorial norms, which gives rise to different laws, can be ameliorated to some extent by harmonization, substantive harmonization. So in fact, if you look around the world, most trademark laws are probably 80 to 90% very, very similar in terms of the formal content that you will find, partly because of TRIPS. And that problem of territorial norms is to some extent ameliorated by harmonization. In terms of acquisition, the problem of the need to acquire on a country-by-country basis has to some extent been ameliorated by the Madrid Protocol system, which allows you to make a single application. You still get national rights at the end of the day, but the costs of the acquisition process have been reduced by virtue of Madrid. If you are going to revise and solve the problem of territorial actions, you're going to have to do something far more radical, which would be jurisdictional reform. Or enforcement reform, and that is something that the world has seen too radical for any real consensus at the moment. But you can see that once you separate them, you identify a little more precisely the particular problems and the particular solutions. It also becomes apparent when you separate them that we have different conceptions of territoriality at play in trademark law. And I want to draw in particular a distinction between what I called intrinsic territoriality on the one hand and political territoriality on the other. And the way I'm going to try and illustrate that is by a pretty famous American case, which is United Drug and Rectennis. You may know about this, and there are analogues to this in Canada and the United Kingdom as well. Basically, in 1877, Mrs. Regis, who was a predecessor of United Drug, who ends up being the plaintiff in the case, uses the mark Rex on medicinal products in Massachusetts. A couple of years later, Mr. Rectennis does the same thing on almost identical products in Louisville. All right. Question in the U.S. courts, which is, of course, is a system in which the person who is the first to use gets the trademark rights, is can United Drug, on the basis of its use in Massachusetts, the first use in the United States, preclude Mr. Rectennis from the Louisville market, from continuing to sell in the Louisville market. And the Supreme Court, perhaps surprisingly, but perhaps not, said they couldn't do that. Right? In fact, not only could they not stop Mr. Rectennis from selling in Louisville, they couldn't enter the market. He actually could exclude them from the Louisville market. That is to say, what the court recognized is that, in fact, there were two different marks. They're both Rex on medicinal products, which may make you think they're the same marks, but they're different marks because what a mark is an embodiment of goodwill, and there were two parcels of goodwill. And the parcels of goodwill were defined to some extent along one dimension by virtue of their territorial use and reputation. So the meats and bones of trademark rights in the United States are defined by the sign, Rex, by the product, medicinal products, and the territory in which they are used. And so that's how we actually get the scope of trademark rights in the United States. Now, why did the court do that? The reason the court did that was because of the intrinsic purpose of trademark law, which is to protect consumer association. So if you think about it, if you were a consumer in Louisville, and in 1912 someone is using the mark Rex on medicinal products, you assume it's from Mr. Rectennis. If in fact we allowed United Drug, the successor to Mrs. Regis, to use in Louisville, consumers would be confused that we've been meddling interference with the source origin function of the mark Rex in Louisville. So in order to protect the functions of marks, we actually, the intrinsic purposes of trademark law, we define the trademark with a territorial dimension to it. All right? Now, if you actually read the main part of the opinion, the Supreme Court contemplated something that in fact came to pass. If I highlight the full language from 1918, federal registration principles are in the United States, as in Canada, as in the United Kingdom, now superimposed on the common law principle of territoriality. Right? So the Supreme Court anticipated that, said in the absence of valid legislation, that rule that we found in United Drug would apply as a common law matter. But of course, to encourage the development of a national economy, and this happens in Canada, it happens in the United States, and it's important to remember this objective when we look at the European question. To encourage the development of a national economy, Congress in 1946 actually enacted the Lanham Act because trade is no longer local, they said, but is national. And the most important word in there is a very small word that I want to highlight, because when we come to European discussion, I'll question it, is the word is. It's in the present tense. Trade is no longer local, but it is national. The United States economy by 1946, in the wake of World War II, was a national economy. I would suggest maybe the European Union's trade is not yet actually fully regional in the same way the United States was national in 1946. Now, what's important here is that Congress did this and essentially created constructive use throughout the United States from a federal registration in order to facilitate, as a matter of economic and industrial policy, a national market. All right? And now, without going into the complications of the interaction between registered and common law rights, it's important to recognize that the registration rule, as opposed to the rule from United Drug, is in fact essentially a political, economic, industrial policy choice. It's not a choice tied to the intrinsic purposes of trademarks to protect source identification. The territorial character of the Lanham Act, which is a national federal statute, is due more to the policymaking enforcement apparatus of Congress rather than the intrinsic purposes of trademark law. Likewise, consider some of the other propositions that I mentioned a few moments ago. The territoriality of trademark laws, right? The formal trademark acquisition practices, trademark enforcement mechanisms, they all tend also to reflect a political notion of prescriptive power. Right? Practical concerns about enforcement, what is the jurisdiction of a court, those types, what is the legitimacy of a legislature. And these rules, therefore, have a territorial character because of their connection to the political sovereignty of the institution that actually defines their scope. So we have some aspects of territoriality, that's the rule that came out of United Drug, that are rooted in the social and commercial practices in a particular society, and that those social and commercial practices dictate the reach of a brand. Right? How far will the reputation extend? Well, other aspects of territoriality are a function of political or policy-making authority. Now, you may say, why does that matter? Why get into this convoluted description of what is apparently a very simple proposition that trademarks are territorial? And the reason I do so is that in an era of digital communication, an era of global trade, social and commercial uses are less territorially confined and less inevitably mapped to the nation states. They tend to be very, very fluid, whereas political notions of territoriality actually haven't changed dramatically. Largely, nation states are, in fact, the dominant political powers that set economic and industrial policy. Now, if the territorial character of a rule, I would suggest, in fact reflects the intrinsic purposes of trademark law, trademark protection itself is going to inevitably mutate as those social and commercial practices change. They're actually tied to the particular developments. And that actually has happened with our conception of use in the United States, for example, where clearly courts recognize doctrines like natural zones of expansion in the early and mid-20th century. They now recognize that your reputation can actually extend way beyond your use by virtue as a result of our new forms of communication. If, however, the territoriality of a doctrine mirrors the political institution, then in fact we're going to have to revise, I would suggest, the political institutions before you're going to see great change in those particular doctrines. Now, actually I have a couple of slides which actually suggest that, so I apologize for not being PowerPoint adept enough in flicking through them. Now, you might object to this analysis, or one objection you might actually think about is simply by saying, all right, what you've observed is the difference between a use-based system in the United States and a registration-based system in Europe. And what you're talking about, therefore, is only going to be of relevance in the United States. But one of the things I'm going to try and show you is exactly the same problem, exactly the same issue is found in the European Union, notwithstanding the supposedly registration-based nature of trademark law. Now, you can find, that's the quote from Advocate General Sharpston in her opinion in the Leno-Merkin case that I will mention in a minute. And that is phrased in the language of trademark registration. Whereas when you hear trademark territoriality talked about in the United States, certainly, to be fair, you will see that it is phrased more in the language of use. So clearly, there is a perspective, a vision of this issue that may be affected by whether you're coming from a theoretical starting point of the EU or the United States. But as I say, I'm going to try and show you in the European context that you will see both of them in the at play in the European context, and therefore suggest that it's not simply a function of the use versus registration divide, but something more pervasive in trademark law. But before I go on to European examples, which is going to be most of the rest of my remarks, I want to just highlight instances, a couple of instances in US law where the concern about the national economy and the economic policy and the political aspects of territoriality have overlaid the intrinsic conception of territoriality that the Supreme Court articulated in United Drug. In one case, I'll mention, as you may be aware of, it's a pretty famous Second Circuit case from the United States, a case called Don Donut, in which the plaintiff sold and had been selling mix for baked goods, donuts, under the mark Don to bakers, including in New York from 1922. Later on, after there's a registration, the defendant starts using Don for retail baked goods, basically selling donuts at their stands, in a particular area where, even though it had a federal registration, the plaintiff did not presently use the mark. And the court should, if it followed purely intrinsic purposes, say no relief necessary in this instance, because the consumers in the little area of New York where they sold the donuts didn't have any understanding of the plaintiff's goodwill. They did have some understanding of the defendant's goodwill, and they weren't both using in the same area, and there was no confusion. Therefore, no need to grant relief. But they recognized that you get constructive national use with a registration for political, economic policy makings. We want our trade to be national. And so they recognized that the person with the priority was, in fact, the plaintiff, Don Donut. By the same token, however, to reflecting the intrinsic purposes, they actually decided not to grant an injunction. They said, you have priority, plaintiff, and when you are ready to sell into this area of New York, come back to us and we will then grant an injunction. But absent you doing that, there is simply no reason connected to the intrinsic purposes of trademark law to grant you relief. Now, you may say, well, okay, that's a mix of the political overlay on the intrinsic purposes that is only a temporary relief, because eventually when Don Donut moved into upstate New York, you would actually have the intrinsic purposes of trademark law meshing completely with the political purposes. But I want to suggest there's also a more recent decision which I think shows you a much more pragmatic blending of the two conceptions of territoriality. It's a case called Gruppo Giganti, in which this is an application of the well-known mark doctrine under the Paris Convention in the Ninth Circuit in California. And the question was whether a Mexican supermarket who moved across the border into Southern California could preempt and exclude from the Southern California market an American producer who had adopted, after the Mexican company had started selling in Mexico, but before the Mexican company started selling and opened stores under the Gigante mark in Southern California, on the basis that the mark from Mexico was well known among Mexican-American immigrants in Southern California, which is obviously a sizable part of the Southern Californian proposition. And the Ninth Circuit said, we need an exception to the territoriality rule, and the well-known mark doctrine is in fact an exception to the territoriality rule. And the reason, they said, is if we didn't do that, there would be confusion. Mexican Americans in Southern California would think they were shopping at a store affiliated with the ones they knew back home. And in order to protect that goodwill that's existing in Southern California, even though there was no stores open by the Mexicans at that stage, we need to grant priority of rights to the Mexican company. But what was interesting was the court, the first time ever an American appellate court, actually considered the level of a consumer association that would be required in order to make out the claim if you are the Mexican company. And as a matter of the intrinsic purposes of trademark, you would say, well, if there's any secondary meaning in that public in Southern California, then we should protect it, and that is enough to trigger the rule. If, however, you did that, you would begin to treat Mexican use the same as American use, the same as Canadian use, the same as French use. And that, said the court, would completely obliterate the political notion of territoriality. There's a border there, and we have to give some weight to the political border, even though we're also giving weight to the intrinsic purposes of trademark law. So what they actually came up with was a standard that's since been called the secondary meaning plus. No one really knows what the plus is, but it's something more than you would require simply to further the intrinsic purposes of trademark law. All right, so American law, I think, has these two different conceptions of territoriality. Let me try and situate some of that in current European trademark law, and I'll try and be brief, but I want to just set the background so you might not all know all the details of European trademark law. In 1988, the European Union adopted a European trademark directive which harmonized legal norms. So basically now, for all intents and purposes, the substantive law of the national registered trademark systems in Europe are all one and the same in terms of formal norms that apply. But even after that harmonization, remember, rights are still territorial. Enforcement is still territorial. Acquisition is still territorial, even if we've got harmonization of norms. And that's actually where the regulation came in, because in fact, what the regulation did and what the assumption was of the Commission was that even with the norms being the same, if the rights are different, are held by different people, or if the enforcement can only be achieved on a country-by-country basis, then in fact we still have impediments to the free movement of goods throughout the European Union, which is one of the objectives of the system. And so as a result, they recognize that what we have to do is create a right that goes beyond territoriality, and enforcement that goes beyond territoriality. And you see that in the justifications in the recitals to the trademark regulation. But in these recitals, I just want to highlight two competing conceptions of territoriality. The political conception, which looks a little bit like the Canadian-American legislative history in the enactment of federal registration systems, which is to try and create an economic market, economic policy, that is broader in scope than it presently is. And secondly, a function of marks, a purposes of trademarks that corroborates or validates what has been the historical function of marks, which is to protect source or origin. Both of those are embodied in the recitals and justifications for the CTM. Now, the CTM does many things. I'm going to try and go through two or three that are really very, very important. The thing is at the heart of the CTM, however, is that it is a unitary right, and I put up the provision from the regulation that articulates that. That is to say, the mark is valid for the whole of the EU, or is not valid at all. It's all or nothing is the basic proposition. At the acquisition level, that presents obviously a possibility of vast cost savings because you get 28 countries with a single application. In terms of enforcement, the prospect was held out of getting a single judgment valid throughout the whole of the EU by suing in a single court in one country of the European Union. And finally, because it was a unitary right, and we'll come back to this very briefly, it was thought you only needed to use in a single country in the European Union in order to maintain the registration. So the unitary nature of the CTM is the heart of it, and you see this as actually what addresses the problem of acquisition and addresses the problem of enforcement, right? Rather than the harmonization directive. But this CTM and the unitary character, unitary principle is reflective of a political change in Europe from a national authority making economic and industrial policy to a European-wide authority making policy. Not a change in the markets as such. It's an aspirational change to a single market, but you will still find among the 28 countries of the European Union obviously different markets. And I think the tension between these two different issues of territoriality or conceptions of territoriality play out in 3 or 4 different areas of European trademark law that I am going to mention. I'm just checking my time, a little bit. The first one I want to talk about briefly is distinctiveness, which you probably all know, the concept in American, Canadian trademark law. Basically, in order to be protected, a mark has to be distinctive. In the European system, you have to get over all the potential absolute grounds, so it has to be distinctive, non-descriptive, non-generic, what have you, non-functional if it's a shape. And you have to also get over all the relative grounds. And that means that there can't be a mark anywhere in Europe. So a single Greek mark somewhere in Greece is enough to defeat your CTM application. You have to go country by country. So it's harder to get, but if you get it, obviously it's a bigger prize. Right? That Greek example is, in some respects, shows you the tension. Because clearly, thinking of our United Drug case, it is absolutely perfectly sensible to ensure that the Greeks who understand a mark to mean a particular thing are protected in the integrity of that consumer understanding. Right? But it obviously also interferes with the free movement of goods if someone else in Europe actually has the other 27 countries by way of trademarks. All right? In the context of distinctiveness, you have to show that the term is not descriptive. If it is descriptive in any single part of the European Union, so if it's a descriptive term in Finnish, right, which would be arbitrary to everyone else, with all due respect to the spread of Finnish throughout the European Union, then in fact it would be unprotectable. And the courts have held that the secondary meaning that you have to establish to overcome a descriptive rejection has to be shown in every part of the EU in which the mark is initially descriptive. They have rejected the idea that you can show that there is secondary meaning in, for example, a substantial part of the community. All right, and that came in way back in the 2000 case, but has been endorsed in a couple of cases recently. Some push back a little bit on shapes, on the assumption that maybe everyone speaks the same language in terms of shapes. But the courts have been very, very insistent that, for example, if a term is descriptive in 20 countries, you have to then show acquire distinctiveness, secondary meaning in each of those particular country. Right? So the vision that that you find of the in distinctiveness of European Union is basically that, which is it's not actually one territory. It is still 28 territories, and if it's a problem in any one of them, you better overcome the particular problem. In other areas, however, the Court of Justice has articulated rules that appear to view the European Union as a single integrated territory. But even here, I'm going to suggest that the intrinsic purposes of trademark may make them, or may inform how they decide cases in future. What I'm going to start with is dilution protection, which is, I guess, a more thorny subject in Canada. But in the European Union, at least, marks with a reputation obtain protection against dilution. As you know, is basically is protection that is not dependent upon proof of confusion. In a case called Pago versus Terramilch, the applicant's mark had a reputation in Austria. And the question came before the Court of Justice, was that a reputation in the community such that they got dilution protection because they could not show confusion in order them to stop the defendant engaging in the allegedly infringing conduct. They were relying on dilution. The test that the court came up with was that you must be, to have a reputation, you must be shown to have a reputation by a significant part of the public in a substantial part of the European community. And they accepted that the territory of a single state may be a substantial part of the territory of the community. They actually strictly sent it back to the Austrian national courts to work out whether Austria was substantial, and you can guess the answer to that question if you are an Austrian national judge. Are we important? Yes or no? Interestingly, if you read Advocate General Sharpston's opinion in the case, what is really striking is the fact, and she's consistent in this through a number of opinions, is that you must consider the territory of the community regardless of frontiers. You basically erase all the borders. They seem to be taking the EU as a single integrated territory, a political defined set of territories rather than something connected to distinctiveness, descriptiveness, the intrinsic purposes of trademark law. And in fact, that approach in Pago was largely appeared to be gaining the upper hand in a case that followed on under genuine use, a case called Leno-Merkin, which asked the question of whether or not use in a single country might be sufficient use to constitute maintenance, or to ensure the maintenance of a trademark registration. And following Advocate General Sharpston again, the court said, just get rid of the borders. Just take an eraser and rub out all the borders, and then ask whether, in fact, we've genuine use in this one single territory. But that apparent trend towards beginning to see the EU as its political borders defining the scope of protection as a discrete market relevant for assessment of trademark questions was bucked to some extent by a decision 3 years ago regarding scope of injunctive relief. And I'll go quickly through the background for this. But basically, if infringement is found of a CTM, you are meant to grant an injunction. It's very more sort of German approach rather than English or American approach to injunctive relief. It's more regarded as pretty much automatic that you get an injunction, which is a controversial issue, obviously, in intellectual property generally at the moment. But one of the great goals of the CTM was you would get that injunction for the whole of the EU, particularly and most importantly, of course, if in fact you were suing in a community trademark court that they created on the basis of what's called domicile or international jurisdiction. Without getting into the detail of that, the most important features here is that CTM courts are, unlike the unitary patent courts that are about to be created, not actually community courts. They are actually national courts commandeered to serve in the afternoons as community courts. So the British government designated the High Court, the Patents Court in England, so that a trial judge like Mr. Justice Arnold, for example, in the morning is sitting as a British judge. In the afternoon, he's seeing a CTM case. He puts on his European hat. He's now a European community trademark judge deciding that particular case. But he can have international jurisdiction if, in fact, the claimant, the plaintiff or defendant, is domiciled in the United Kingdom. And the question is, when that happens, what is the scope of the relief he grants as a community judge in that particular case? It was assumed it was European-wide. This case from France, DHL and Chronopost, has tested the limits of that to some extent. And this is a case where Chronopost owned a French registered trademark and a CTM for web shipping for, you'll guess, web shipping. It says something about the registration process, that they got web shipping for web shipping, but that's a whole different point, separate and apart from the scope of injunctive relief. They bring an action in the French court alleging infringement. It's not entirely clear. It's typically a little Delphic, the French judgment, but it appeared that they adjudicated simply based on initially on the French mark, but the appellate court clearly granted the relief on the basis of the CTM. And the question was, what scope of injunction should it give when it has based its jurisdiction on this international, so-called international jurisdiction? And that case goes up to the Court of Justice. And it's interesting is the Court of Justice answers the question in paragraph 33, saying the scope of injunction is determined, I'm now paraphrasing to connect it to my work, but I'll give you the exact language in a minute, by the territorial jurisdiction of the court. That's a political notion of territoriality. And the territorial extent to which the functions of the marks were adversely affected by the infringement. Now that's a little bit of Eurospeak, this adverse effect on functions. But it's basically asking is, in what territories would there be confusion? That's the sort of translation of that particular formulation. All right, that's actually the way they phrased in a longer form that particular rule. But basically, you start with the idea that you're getting EU-wide relief because that's the political scope of the jurisdiction of the court. And then you might cut that back if, in fact, you see that, in fact, there is no confusion in a particular place. Now, to skip forward to the sort of the punchline as to when that would be, it's basically the second bullet point down there. If the defendant proves that the use of the sign was not liable to affect the functions of the mark, for example, on linguistic grounds. So it may well be, in this case, is it possible that maybe the French consumer would be confused, but the English consumer, remember it's an English language mark, might not be confused because they understand what web shipping means in a truly sort of primary use of that term, a descriptive use of that particular term. And what you see from the court trying to do here, I think, is reflect the enduring power of intrinsic territorial notions of marks about the scope of goodwill and distinctiveness, and in some ways reconcile that with the political territorial notion, which is that we are to try and grant relief on an EU-wide an EU-wide basis. Now, more speculatively, I think what it shows is perhaps the limits of imposing a rule of political territoriality when the market is not quite as advanced as perhaps the political structures. Because community trademark courts are national judges wearing their European hats in the afternoon, they tend to look at the questions of confusion, questions of descriptiveness, questions of distinctiveness, as you might inevitably do as a national judge. You sit in the morning, you say, I'm a British consumer, what do I think of those two marks? In the afternoon, you say, now I'm a European consumer. They don't tend to do that. They tend to make exactly the same analysis because it's very, very hard for the judge to think of themselves as a European consumer. It's less of a leap for them to think of themselves as a national consumer. And I don't think, as a result of this, that they really have instantiated the political commitment to a European-wide consumer, because you don't have the institutional structure there or guidance saying you have to think about this as a European consumer that has helped to make the judges make the shift. Now, you may say, well, American consumers or Canadian consumers sit in one particular part, judges sit in one particular part of the country. But I think the political territory in the European Union and Canada is probably more congruent with the market, scope of market and social commercial exchange than you actually have in the European Union. In the European Union, we have created the legal fiction of a unitary market, but we don't have a unitary market actually in fact. And I think what it does is if you recognize that difference, you begin to think about the changes you would have to make. If you wished really to push the issue of a unitary market, you'd have to engage in institutional reform, interpretive reform, conceptual reform that makes institutions like national courts appreciate that they're now acting in the service of the European Union, not simply trying to effectuate the intrinsic functions of marks. Alternatively, if you recognize that courts are always going to be attracted to the intrinsic functions of marks, then you have to start thinking about ways in which you mediate the tension by, for example, coexistence and other types of reforms that have been suggested. I should say, in the meantime, just by way of sort of giving you the details, the DHL exception, although it looks like a carve-out from the unitary aspects of the CTM, in effect, the national courts have actually regarded it as a pretty narrow exception. So when the case went back to France, they actually ended up giving a European-wide relief. And likewise, when it went to the British courts, Interflora, Marks and Spencers, which is one of the largest cases with currently about 10 opinions on different procedural matters, that's been going through the courts and is actually currently has been heard in the Court of Appeal, but we're awaiting a judgment on the merits, which is a keyword advertising case, one of the few successful cases brought on keyword advertising by a trademark owner. Mr. Justice Arnold had assessed and found confusion largely by, as he acknowledged, thinking of himself as a reasonably well-informed and reasonably observant internet user in the UK. He hadn't given the remotest thought to what a German internet user or a French internet user would have thought. And as a result, the defendant, when found liable, said, you haven't worked out whether there's any confusion elsewhere. Therefore, and in a lot of these other countries, there is no jurisprudence finding liability. Therefore, you should restrain the injunction, confine it to Britain, even though it's a CTM. And Mr. Justice Arnold said, no, the burden is on you, defendant, to prove that there is a different understanding in these other countries. A very pragmatic response to the DHL case. So I shouldn't overstate the case that DHL has interfered with the unitary nature of the marks, because the courts are treating it truly still as somewhat exceptional. But the DHL case has brought back into relief a question that was unanswered in Pago. Remember I said Pago, the tension between intrinsic purposes and territorial purposes was still there, even though the court came up with a just take out an eraser and get rid of all the borders approach. In Pago, one of the things that the Advocate General mentioned, Eleanor Sharpston, but the court didn't address, was what happens if, okay, you have a reputation in Austria, and we find Austria is a substantial part of the European Union, therefore you get dilution protection, but they want to stop the use in Finland, where you have absolutely no reputation. She said, I can't see anything that would preclude a court restricting its relief to Austria, because there would be no harm, no association made by the Finnish consumer. So why would you actually grant relief in Finland? Wouldn't you just give a restriction on the use in Austria? Well, this came, the issue was raised in the Max Planck study, which is the review of European trademark law from about 4 years ago. And it's now come up in two cases, one in Germany and one in the Netherlands, in which the court has basically said the dilution claim is also subject to the intrinsic territoriality of the reputation, of the goodwill of the mark. So the Hormel case, those of you who are over 20, over 30 may know this stuff, right? It's the inedible spam, which is a form of food, which sells very well. For some reason, entirely beyond me, and this is why I'm obviously not in marketing, the defendant decided they were actually going to create an energy drink under the mark spam, and as you might guess, Hormel are very, very protective of the spam mark, and they sued in the Netherlands saying, you're infringing our mark. Now, they're completely different goods, so they said, and there would be no confusion. And therefore, there's no confusion claim. They had to rely on dilution, the fact that did they have a reputation. So the Dutch court accepted that spam had a reputation in the United Kingdom. And the United Kingdom is a substantial part, although it may be able to change, a substantial part of the European Union. And therefore, they get dilution protection. However, they said, you don't have any reputation in the Netherlands, and therefore we are not going to give you relief. So in theory, you have your European-wide nice political conception of a regional protection, but the intrinsic purposes of trademarks don't warrant giving you relief, and that is going to restrain and carve back from the political notion. Now, interesting, for those of you who are a little older, the most depressing part of this is that the court refused to take into account the Monty Python spam sketch on the basis that most people were too young to remember Monty Python, which I find a little bit biased towards the younger members of the of society. But in any event, Hormel validates the proposition that you find in Advocate General Sharpson's opinion in Pago, but which hadn't been addressed in court in Pago, that the intrinsic territorial nature of a reputation might actually restrict the political grant of EU-wide relief. All right, so what is to be learned from all of this? And I'll just try and wrap up as I'm a couple of minutes over. First, I think one of the ironies of the tension that you see in DHL and you see in Pago and you see to some extent now in the Hormel case is that the reluctance of the European courts to implement faithfully, and I don't mean that critically, I'm not trying to be critical that they're being in some ways unfaithful to the legislative purpose, but their reluctance to resistance to absolutely following the political territorial nature of the EU that their legislators have commanded them to follow is in part a function of the growing size and diversity of the European Union. If you had, back in 1957, 6 countries, largely contiguous, largely economically similar, speaking, if you put aside the different variations within Belgium, largely the same languages or similar Romance languages, then in fact the CTM made perfect sense in 1957. The irony, as we start trying to expand both the European Union and the scope of protection, is that those actually are in tension. The more diverse that the European Union, and larger the European Union becomes, and therefore there's a larger impulse, people say, to getting a broader EU-wide right, in fact makes it less practical because you run into tensions with local markets that still exist within that larger union of 28 countries and now 22.5 languages. It depends how you classify Irish Gaelic and those particular things. Now, the only way we will actually deal with this, I would say, is in fact hearkening back somewhat to the American systems and to some extent the Canadian systems, and that is recognizing concepts such as coexistence of rights, remedial flexibility, use of disclaimers. Because we will otherwise have too many conflicts in this one large global area or regional area in order to have a continued supply of marks. To state the matter a little bit more conceptually, I started the remarks by saying there was a danger in the law lagging too far behind the realities of the marketplace. There may also be a danger in the law getting too far ahead of the realities of the marketplace. It may well be that the law needs to be a little less progressive with a small p in moving on the political changes that the CTM sought to bring us. And that might not be a bad thing. If we value the difference of different markets within an integrated community, then in fact we should be willing to reconcile and deal with reconciling the intrinsic purposes of intrinsic territorial aspects of trademarks and their different pockets of goodwill with the political vision of the European Union. To put it in a broader perspective that may be more relevant for a Canadian or North American audience generally, is to say that as countries think about whether they should mimic the CTM, I think it requires a little hard thinking about whether territoriality is best reconfigured by a political top-down approach that says thou shalt be a single market regardless of difference, or whether in fact there are devices within trademark law, doctrinal devices within trademark law, tied more closely to the actual scope of goodwill that actually allow us already to reconfigure territoriality in ways that don't get too far ahead of what the market actually allows. So apologies, I'm 5 minutes over, but I promise I'll stop and we can get some questions. Thanks.
Most interesting. Thank you, Graeme. I just want to take you right back to the very start of your proposition that there's a difference, which I guess you're trying to put in binary terms, between intrinsic character of a trademark and its political character. And I wonder how far that actually goes, because it presupposes that the judicial creation of trademarks through the passing off action and unfair competition actions and then initially with registration systems didn't have its own political character. In other words, the courts themselves weren't operating on a policy which says, first of all, we don't want to encourage fraud, and we extend the fraud action to cover third parties as distinct from the defrauded party, and then we go one step further and create a property right in it so that we remove any issues of intention. And really, that what has occurred is that the political character is, I suppose, there is a limited political character that the courts can advance, but it's not. I wouldn't have automatically have thought that it was unpolitical. I think, right, in a way, you're saying you're drawing a distinction between judicial function and legislative function. Legislative function is political, and judicial is not. But if that's what you're drawing, I would query whether that's as cut and dried as all that. Second thing that I want to just ask, of course, or just point out, you treat, and it's interesting that the analogy you're making between the United States as a federation and Europe as a federation trying to do the latter proposition, of course, is one which would be taken to task. but an amalgam, a common market of states, and the United States is a common market. And I'm not entirely sure that it is a one-to-one analogy, and certainly insofar as Canada is concerned, the idea is, of course, that even though you have limited use in a particular market, you do get national rights, and you do get the right to enjoy nationally, even if you don't operate in the particular area. Perhaps dilution might be, there may be some ability to modify an injunction in a dilution case, but the theory is that if I get a trademark currently, forgetting about the current reforms, based on use in Vancouver, I can stop a use in Newfoundland, even though my reputation doesn't extend beyond Vancouver. So the Dawn Donut example doesn't have a complete resonance, I don't think, in Canada.
All right. Both good points. Let me pick on the second one first, which I take the point that the whole point of the registration is that you have the national rights. And with a large number of goods, and you have to remember Dawn Donuts is 1959, the large number of goods, you're never going to be able to make out the case. The nature of the goods is that you're never going to have really retail sale of fresh donuts was a in some ways relatively specific and special kind of example. But if you had something like that, you think a Canadian court would enjoin? There wouldn't be no consideration of the equities of an injunction? They would just automatically say you have registered rights. So let's assume it's after, well, in the current system you've used it, and we say, well, enjoining even though the people in let's say in Nova Scotia are no idea of either of the marks.
If it's the same mark, the answer would be yes.
Yeah.
It's federal.
Yeah, Dan Bereskin thinks that's a little more iffy. So I'm intrigued. I don't think there's any case law. I think I read he just said there was no case law on it.
No case law. In principle,
yeah.
If you have a national registration, what's the point of a national registration if you don't have national enforcement?
Well, the point, I mean, so if you go back, if you pick up on what the Second Circuit said in Don Donuts, the point of the national registration is that you have priority in that case, the whole country, and if you want to sell in there, you can kick them out, right? That's so you always have that potential. It's inchoate, right? You always have your option, but we won't grant you relief if, in fact, there's no harm occurring in that particular area. So you're getting the priority. You just won't inevitably get the immediate relief. That's at least the Second Circuit's formulation.
I'd query that. But
Yeah,
anyway,
yeah.
So far as Lisa's Canadian situation.
Yeah. So, so that's interesting. Though. I mean, that you wouldn't think that there would be sort of introduction of the equities in the Canadian sort of standards of injunction. Second, I take your first point entirely. I mean, you can go back to is any property pre-political, right? I mean, in some respects, every decision is political. So maybe, I'm presenting it as binary, I think, because it makes it sort of easier in some respect. But you're entirely right that there's a subtlety there that probably needs to be introduced, which is probably is more, I wouldn't draw the line as judicial versus legislative. But what I would say I think is quite right, which is there are more overt political functions going on in the context of acquisition and economic industrial policy than you will see now going on in the concept of validating source and origin identification functions. So maybe the best way to put it, I think it's a fair point, is to say that it's in relative terms, there are territorially based rules that are more tied to this sort of politically accepted intrinsic function of marks, whereas on the other side, in terms such as economic industrial policy, judicial scope of jurisdiction, those are purely political conceptions of territoriality. So I think that's a fair point. I will accept that.
Okay, we have a question here.
Sure. Hi, my name's Carrie Johnson. I went to Osgoode. I graduated in '94, and I've been practicing in intellectual property ever since. So I'm finding it interesting. It looks to me like the EU is actually a dog's breakfast, and essentially, as a practitioner, it would be extremely difficult to actually advise a client because the judges themselves seem to be going all over the place. And I follow the EU case law because I do a lot of work in the EU, et cetera. But the other thing that I'm noticing as a practitioner, for one thing, too bad you weren't here to talk to the Canadian government just before all those legislative reforms. I'm sure you're aware there was a huge uproar amongst the practitioners because they never really consulted with us.
Right.
And the EU system isn't working very well, as you know. There's a whole bunch of issues around classification of goods, et cetera, et cetera.
Right.
Also, what I'm noticing, because I'm going to the working group meetings in Geneva at WIPO for the Lisbon Agreement, and what I'm seeing is a huge shift in terms of who's running the world on the intellectual property law, in terms of intellectual property law. Whereas before, probably up to about 2003, the United States dictated a lot of what was going on. I don't think that's necessarily true anymore. I think that the EU has gained enormous ground, especially in the area of trademarks, geographical indications, and all the rest of it, from the fact that they've been negotiating all the bilateral treaties that they've been doing. And so I think that that's something you should be considering because there's a huge shift. And if that shift is towards the EU, and the EU hasn't internally worked out all their problems, where does that leave us in terms of intellectual property law in the long term?
To take your point, first of all, on dog's breakfast, I mean, there clearly are problems with the European trademark system, and the reforms at the moment that are going through both the regulation and the directive, I don't think adequately address many of them. And in fact, the study that was produced by the Max Planck Institute, I think, actually had many sensible reforms that weren't picked up on in the Commission. I think, well, to be fair, they picked up on some and the Parliament has knocked them out, but there still are problems with it. It is a young system. I mean, to defend it for a second. I mean, it is a young system in the sense that attempt to bring together, even though they're nominally applying the same rules, culturally different attitudes to trademarks and indeed to adjudication in one system is very, very ambitious. And in some ways, it's over-ambitious. All right? So one has to sort of look at it to some extent through that lens. I think the other reason you probably think it's a dog breakfast is to some extent there is just too much law. The 30% of the cases going to the general court, so the court just below the Court of Justice, are now trademark cases. Because of the number of cases being appealed up through OHIM, through the boards of appeal, and the number of references being sent, it's almost impossible to keep track of the number of cases. And that's a particular problem because what you now have is the Court of Justice and the General Court opining on levels of minute detail on what to me are basically factual questions on things like confusion, and as a result of which you have to try and reconcile 80 confusion decisions, and you would not normally have those addressed by higher courts.
Well, what I observe as a practitioner is that really it's very fact-based. It's almost like dealing in family law. So almost every single decision that I read, the court is really basing it on facts. And the EU hasn't worked out a lot of fundamental issues on a lot of IP-related issues. So, and yet they're running the show. Whereas the US had sort of a, and I don't agree, and I don't agree with famous marks or whatever. So I'm not in the US court. But what I see is at least they had a sort of a perspective, and you know, the EU hasn't figured out how to deal with transport of illegal goods. You know, it just goes on and on. So I think that ultimately the system right now is in a state of chaos on an international level because you have this shift in power, and now you have, with respect to the Madrid Protocol, you have that Norway proposal coming in from that's backed by China. I don't know if if you're familiar with it, but what it does is it removes the requirement for the basic mark to stay in place. So, for example, China might use a specific mark in China. They apply internationally. They are never going to use that international mark in China, and they want to remove the requirement for the basic mark to be held nationally. So that's a major shift in policy on the trademark.
All right, a couple of quick, without getting into the details of the Madrid proposal. Again, I think if you examine in minute detail, I think you're quite right. There are a lot of problems with European trademark law, but as I say, I think you have to give them a little bit of slack in what they're trying to achieve. And my view is if in fact one didn't look at any general court law, and that may be a very big if, right, on those kind of issues. The Court of Justice, whether you agree with, for example, what it's done on unfair advantage or whether it's being too stingy with exceptions, I think there actually is a coherent doctrinal body of law there. Maybe wrong normatively, but it's relatively coherent. I think the problem is the level of detail in which they're intruding into national courts making determinations in trademark cases. And the easiest reform that would get rid of that is some constraint on the appellate jurisdiction, which is that at the moment there are appeals of right all the way up, and references are required in a large number of cases. And I think both there needs to be some reform of the jurisdictional rules such that courts have a capacity to exercise discretionary authority over whether to take particular appeals. And frankly, national courts need to stop referring as many cases. The German courts have a much more pragmatic approach. They technically should refer a lot more cases than they do. And they, using doctrines like Act Clare and what have you, have managed to refer perhaps fewer cases than, say, the British courts. The British courts, for all that they are sometimes thought, Britain is sometimes thought to be not as pro-European as some other parts of the European Union. The British judges are tremendously faithful about referring cases, sometimes getting very bad answers, they think, but they are very honest about doing that. And the truth is that's sent up so many cases that we have a body of case law that is unwieldy in part because of its size. and the factual nature of the issues it's addressing.
But I also think that historically, because the U.S. was running the international treaties, there was a perspective that there was actually a lot of international trade in trademarks. I think if you actually analyze it, if someone did an actual analysis of how many trademark owners export outside of their national borders,
right,
the numbers are incredibly low. So what you have is large corporations dictating laws that really don't relate to most trademark owners, because the majority are maybe not registering, but in terms of common law use, there's a lot of small companies versus you have a few large companies dictating the international law.
All right, so the point you're making is that you don't think there's been, if I take your point correctly, and I may be misstating it, so correct me, but is that you don't think there has been much multiplication or enhancement of cross-border trade, notwithstanding digital communication technologies?
No, I think if you actually look at what we're really talking about is 500 interested parties.
All right.
Maybe that might be low, but
yeah,
essentially, how many companies are really trading across all those
well,
borders?
I'll also agree with you on one thing, and then I'll disagree only because we're both trying to probably prove something that is empirically sustainable, but I haven't seen studies on. So the thing I'd agree with you is, do big companies drive the development of trademark law? Yes. Do big companies drive the development of almost everybody of law? I would probably say yes, all right? I don't think trademark law is unique in that respect. Patents is interesting in the context of some of the changes in the United States and the IA, but I think that's a broader critique perhaps of lawmaking rather than trademark law in and of itself. On the other question, which I say I disagree only because intuitively I think something else, but I don't have anything to back it up, is that I do think there is more cross-border trade. I've actually tried to work with German and Dutch cultural geographers and economists to try and measure consumption patterns and how they've changed since the introduction of CTM, and we haven't got that project off the ground yet. But it's a very interesting question, and indeed you have some people who would support you. I mean, I've given this variants of this talk at other places, and a couple of people from the United Kingdom have said, there's just trademarks are just still being going in the same patterns they always were. And it's my experience, but it's purely intuitive, based on experience, is that I see, for example, marks in the United States now that I would never have seen when I moved to the United States 25 years ago. And likewise, I see American marks in Britain that I would never see. Now, some of them are large. Budweiser is a classic example, all right? But I think you also see small companies who manage to ship and produce and sell across borders in ways they didn't do 20 years ago, partly because of e-commerce, largely, in fact, because of e-commerce, and some extent because of liberalization of the trade rules. But that's an empirical question. I have nothing to prove it other than my own sort of gut instinct on that point.
We have a question over here.
Hi, my name is Sasson. Sorry, I'm a PhD candidate at Osgoode. I'm not really interested in trademarks or IP per se. I'm interested in what they do with the flows of money.
Right.
I'm looking at that unitary trademark that covers all the EU. Where would that unitary mark be located? Because just to give you my context, you can have a Canadian trademark that's owned by a Bahamas company. It's considered personal property, so it's in the Bahamas. Any payments flow to the Bahamas because that's where it's located. What would happen with the unitary mark? Where is it?
It's personal property, but the property, interestingly, most of the trademark rules under the regulation are set out substantively in the regulation. But one of the few exceptions to that is on the rules of property, which are, if I remember right, delegated by choice of law to the law of the domicile of the trademark owner.
Okay.
Now, the exception to that is if it states a substantive rule in the regulation, then it will trump, right? It's a sort of essentially a federal rule. So, for example, the rules on how you assign a mark, what constitutes a valid assignment, what you can do by way of licensing, those are all set out. To the extent you have a rule on a subsidiary rule of national law of property that might affect transfer or money flows, then you would follow the choice of law rule that takes you by way of subsidiarity down to the member state. So it's not a pretty simple answer. But in terms of money flow, I'm not quite sure. You mean, are you talking about where it is located for purposes, say, valuation or tax?
For tax purposes. So, for example, if there's only one mark and it happens to be located, let's say, in Switzerland,
Right.
there's no business in Switzerland, so let's say you can't get injunctive release in Switzerland, but all the royalties go to Switzerland while you sell in Italy, the UK. So the protection is provided in those countries where you're getting money from, but the money flows out of those countries to a nation where you have no protection and you wouldn't get injunctive relief, but the mark happens to be located because there's only one mark.
All right, so I think I see where you're going. So yeah, the short answer to that, yeah, if you have a mark CTM, and what you're saying is all the financial benefits are being realized because of a variety of commercial arrangements that are going to Switzerland. The fact that there is financial reward being secured in Switzerland does not in any way affect the scope of the CTM, but it's still a European instrument. It only protects in those countries. So what you're interestingly arguing is there were an issue of basically extraterritorial enforcement. And for a while, the U.S. courts, and this is particularly true in the Ninth Circuit, in order to whether apply American law extraterritorially, for example, to restrain conduct that occurred in foreign countries based upon an American mark, they need some effects in the United States, some substantial effects for constitutional and other purposes and comedy purposes. And for a while, you could see a number of cases who took that meaning of what a substantial effect is, that an American company lost money. And that would be the equivalent of what you're saying, which is that a financial hit is in fact an effect that might allow, for example, Switzerland essentially to apply its laws extraterritorially to protect a Swiss mark against conduct in the European Union. But that doesn't affect the formal scope of the CTM, which is a European bit of property. And nor would I suggest in most countries of the world would you have an interpretation of extraterritorial enforcement that is based simply upon the profits of a particular company. There's a couple of Ninth Circuit cases sort of late 1980s in the United States, but on the whole, they're exceptional. You want a mere financial connection won't be enough to extend the scope of protection.
Okay, thank you.
Can you just make your way to the microphone?
My name is Justice, first year PhD with research interest in intellectual property. My question is with regards to setting up a model similar to the CTM. You mentioned that a number of countries are trying to mimic the system. What do you think are the major challenges, inhibiting the process? That's one. And then two, do you think having an established regional structure like the EU would facilitate such move or would kick against it?
All right, two great questions. In terms of the challenges, I think the challenges are primarily, at least as the European system would throw up, when you have components in the regional country components within the regional grouping who are very, very diverse culturally or linguistically. And so it's interesting that the two African groupings where the trademarks have been developed, the English-speaking countries and the French-speaking countries have their separate unions. And I think that reflects the importance of linguistic and cultural aspects to the scope and reliability. I think that's the biggest lesson you would get out of the European Union, and it plays out in interestingly more extended ways than you might just think about the two or three issues I mentioned. So, for example, at the moment, one of the reforms that was rejected in the directive that's pending, but the Commission had initially proposed, was to require national offices to examine for descriptiveness in all 22 languages of the European Union. And the practical logistical problems of that, I mean, in Britain we barely speak 1.5 languages. Mostly we're not linguistically as adept as perhaps some other European countries. Getting a bunch of staff at the British IPO to speak 22 languages would be a real practical, logistical and cost issue, and that was as a result thrown out. But one of the consequences of that is you end up with cases such as a case called Matratzen, which is a European Court of Justice decision where the Spanish trademark office granted a national Spanish trademark in a mark with the word Matratzen, and forgive my German because I am one of those non-adept English speakers, which means mattress in Germany, and they granted it for mattresses. And the result of which was the German producers, who inevitably have the word Matratzen on their mattresses shipping into Spain, were potentially at risk of being infringing. by virtue of that. So you have a tension there between trying to ensure the free movement and then the linguistic practicalities that come out of the linguistic nature of trademarks, which of course is not unique to trademarks. I mean, patent interpreting claims of patents raise some of these issues as well. But I think that's one of the big challenges. Your second question, which is about the need for institutions, I think that's actually very important. One of the reasons the EU works, and with all due respect, I mean, it works as well as it does, right, notwithstanding the comments we just heard, and which I to some extent agree, is that in fact it has standing political institutions, courts, legislative bodies, who can make changes when things go awry, who can interpret, who can enforce, who can ensure commonality to some extent within the European Union. If you had to go back to a treaty revision process, for example, every time you wanted a change in the law, or you're relying only on judicial dialogue rather than a central court, then I think you have a real challenge in implementing as fully a unitary system as the European Union has. So the institutional design, which is really what you're asking about, is, I think, very, very important. Yeah.
Thank you, Graeme, for an excellent presentation. Does it work? Yeah? Okay. So in light of the experience in Europe that you're describing and the gap between what happens at the scope of territorial protection and what happens when it comes to enforcement, reeling back in the rights, yeah. Shouldn't you conclude that, in fact, even though one would first think that it would be more desirable to go to a broader scope of protection, that in fact it's impractical, that more global trade would make one think, yeah, we should go for broader scope, but it just doesn't work. And I would pick on what the lady said about intuitive... I didn't hear your name. Pascal. My name is Pascal. You're a practitioner? I practiced for many years, and I'm now a professor at the University of Windsor. So I would pick on the point intuitively that for a lot of businesses, it's still very local. Mm-hmm. You know, even though, you know, we may think you can dispense maybe with having to deal with copyright, with patents as a business, you can never dispense with trademarks. Every business is involved with trademark issue at some point in time.
Yeah.
So is your conclusion that, in fact, you know, sort of the constructive model of registration is something that we should question and really go back to a model where it's more based on the actual use? Well,
I mean, I think to pick up on your premise, and I'll get back to the precise question, your premise is, I think, entirely right. There's a paradox there, which is, as trade becomes more global, the need for locally defined marks that can coexist with other locally defined marks actually becomes larger. And that's the problem that I think that 1957 versus 1994 point goes to. So the concept in some respect of glocalization, to use that horrible neologism, but I mean, I think that actually is a powerful point. Interestingly, and this may speak to the point of big business, when the Max Planck study suggested what to me was an immensely mild form of coexistence, where you had to have had the CTM for 15 years and not used in an area that was geographically remote from the area in which you used, then the junior user could in fact continue using. I mean, that's a really mild form of coexistence, and that was regarded as a complete anathema, all right? Which may suggest that big business had to some extent has hands on that process. So I think in fact you have to look at devices like that, although I would be more aggressive in what I regard as sufficient coexistence. And I think the Court of Justice has given authority in the Budweiser case, in fact, in the United Kingdom, for courts to develop honest concurrent use, as the British would call it, as a way of pursuing that. In terms of whether it gets to your specific question, Pascal, to whether it actually that tells you that you therefore needs to go back to a use-based system versus sort of broader constructive use and registration, I think you can. There are still tremendous values for certainty and other reasons for having a registration system. And much as though it's also important to protect small business, big business is also important in economic policy. So I don't think you need to cut back on the possibility of a registration that covers the EU-wide area. Instead, I would have other devices on the back end that would allow you to calibrate the scope of protection a little more carefully and perhaps a little more narrowly than the current assumptions in the CTM system do. So I don't think it causes me to question as a matter of territoriality, the need for registration. Now, whether that also, and this may pick up on the debate that a couple of people mentioned, whether that there are other reasons unrelated to the territorial question as to why you may be more skeptical about switching to a registration-based system, and Canada has obviously maybe not had the debate, but would have liked to have had the debate about this question. And I think there are other policy questions there, and the European Union, and this is where the dog's breakfast is larger, on the registration side of rights that have, at the OHIM level, you don't even need an intent to use. I mean, you don't even need to declare an intent to use at OHIM level. Those sort of what I would call basically drive-by rights that you can get have had the effect of cluttering the marketplace for trademarks in ways that create tremendous costs, which have to be borne by other producers. And
the efficiencies and
yeah,
so forth.
and that was actually
Huge.
one of the big things that the Max Planck study tried to look at, was whether there was real clutter on the European trademark register, and it had a sort of mixed conclusion as to whether it was there. But there was obviously some, and therefore you get reforms on, for example, 3 classes for the price of 1, and things, small administrative reforms. But actually the biggest reform that I would put in, but I guarantee this will not happen, would have been to re-establish mandatorily examination on relative grounds. One of the trends that the OHIM put in, which is effectively an outsourcing of costs, is that offices, even in countries like Britain, which had pretty rigorous examination on relative grounds, no longer examine on relative grounds. They use the opposition procedure to do that. And that is a function of the influence of OHIM, where that was the practice, being extended to the member states. Now, by the time the review came along, you had basically a 50-50 split. Half of the member states were examining for relative grounds, half of the states were not examining for relative grounds. And so what INTA said was, we just want commonality. Right? Let's have the same rules. So my view would be, yes, I'm fine with the idea that that's a practical reality, so let's make all 28 countries examine for relative grounds. But in fact, what happened was the opposite, which is that the relative grounds are still largely unexamined and will be unexamined under the Commission proposals by the offices in ex parte. So I think the critique of registration, there are critiques of registration that I think might make you a little bit cautious about a whole sort of full-throated endorsement over a use system. But I think territoriality is probably not the one that would be the main ground on which I would object to constructive use. It would be a full-blown registration system. It would be more these other concerns about efficiencies and cluttering and what have you.
Okay. Thank you.
Yeah.
Hi, thanks, Graeme, very much. I enjoyed that. I have a bunch of thoughts, but I think I'm just going to ask one big question and let you run with it. So the big question really is whether you would like to see, whether it's, I think you suggested through the back end, a match between political territoriality and the intrinsic territoriality of trademarks. I mean, is that ultimately the ambition, and you're just conceding that you have this sort of political dimension and there's some, importance to be credited to that? Or are you saying, really, we need to find a way to make our international trademark regime map onto the intrinsic territoriality of trademarks and purposes behind trademark protection?
I think this may be in some ways an echo of my answer to David's question about binary. I think, and this may be a cop-out as well, so which is, I think, I would like it to map it more closely, but not exactly. And the reason I say I wouldn't want to just commit to saying it just has to map is twofold. One is, it seems to me that it's a legitimate place of governments to try and structure economic industrial policy and the expansion of trade and jobs in particular ways. And trademarks are a tool in that, along with many other devices, probably others that are more effective in the way you structure trade. And secondly, perhaps a little more theoretically, I've always had a slight concern with the myth that we perpetrate in trademark law, particularly in use-based countries, that all that judges do is sit up there, take evidence, they see what the market is, and they simply reflect the market. So consumers think X, you've told me this, I can see they think X, I will protect that understanding. Consumers will be confused, I will stop the confusion. It's an entirely mechanical process. And that clearly enhances the legitimacy of the digital function when they explain what they're doing there. But in fact, there are huge range of normative questions, and I need to pick up on David's points again about politics that's involved in those assessments. The normative assessments involved in supposedly empirical assessments of distinctiveness and confusion are actually quite several. I mean, just to pick small ones. I mean, why is it that when we look at marks in the pharmaceutical context, we find them confusing more easily than we would in, say, a candy context? Well, it's a reason because actually the consequences of getting the drugs mixed up is actually much more severe in social terms than it is with people getting the wrong sweets or wrong chewing gum. All right. So there clearly are normative components built into trademark law. My worry again of just saying, oh, let's just map it to the intrinsic function suggests a more reactive and less dynamic role descriptively than I think the judges do perform, or indeed that they maybe should perform, because there are clearly contexts in which we might say, well, consumers think X, but for reasons of free competition or free speech or what have you, we want this to be permissible. So I wouldn't want to go as far as your proposition, but I might nudge somewhere in relative terms along the spectrum towards it. So, okay.
I wanted to say I agree with Pascal.
We have a question.
Yeah.
Professor, thank you so much for your very invigorating talk. It was very enlightening. I am a third-year JD student, and I am intellectual property clinical intensive with Professor Pina and Professor Weaver. So my question is from a perspective of an international policymaker. So assuming I'm an international policymaker and I'm looking at CDM, I think I'm tempted to say that it is probably just trying to fit the traditional concepts of trademark law and trying to apply it in an international globalization market sense. So what should I really do as an international policymaker, really?
So if I ruled the world, was in charge of the Standing Committee on Trademarks, what would I do? I mean, I think the reality of the political structures that exist at WIPO, which is on the whole, is the offices that send the people along and who are government representatives, is that there is inevitable focus on registration. I mean, that's just what these people's lives are, and political economics would tell you that inevitably registration is going to be a very, very big part of what you should be focusing on. So that's realistically going to be a big part of the agenda, and therefore some of the cluttering and other issues that I mentioned, I think would be on the agenda and should be on the agenda at WIPO. Things like class headings, things like rates of price for acquiring multiple classes, things like that. So some of the things that the Commission was thinking about in the European context, I think on the registration side can be extrapolated to the international side. If I did manage to get them to debate substantive issues beyond the procedural administrative aspects of registration, the biggest part of trademark law that I think needs fixing is defenses, is exceptions and limitations. On the whole, trademark law has gotten by through the years with pretty limited exceptions and limitations because the confusion test actually gets you a lot of the way if properly applied. Once you adopt dilution, as most of the world has done, not everywhere obviously, has done. Once you have dilution, you have a very strong property right that encompasses, as a prima facie matter, way too many third-party uses that we might actually wish to permit for a number of country social policy reasons. And I think that the structure of the international, this is not just international trademarks, international IP system, which is essentially a minimum standards with no mandatory exceptions on the other side from most purposes. Copyright may have a couple. Is ill-suited to the dilution regime. It seems to me if you have dilution, the other part of that puzzle, and people may take issue as to whether you should have dilution, but I think we have it, is that you have to have countervailing exceptions and limitations. And this is one of the debates that the European Union is currently having quite intensively in Brussels on the new reforms, in that the Max Planck folks wish to include quite a long list of new exceptions and limitations, and they've been largely gutted in the process of the legislation going through Parliament and Council. In particular, one proposition that they appear to be insisting on that absolutely is destructive of defenses is that you cannot have a defense if it would be if the conduct of the defendant would infringe by virtue of dilution or confusion. Now, the only reason you need a defense, or one of the main reasons you need a defense, is that there is a plausible prima facie claim of confusion or dilution. And the US Supreme Court accepted the illogicality of defenses that have conditions like that in KP permanent. The Court of Justice has before accepted that proposition. The British courts have clearly accepted that proposition. You completely gut defenses when you do that, and I think that would be my main substantive focus if I ruled the world on trademark law.
Thank you.
Yeah.
So I've had to, I'm Bita Amani for people who are in the audience and don't know me, from Queen's Faculty of Law. I've had to adapt my question a little bit because you've already addressed it in part to some of the earlier queries. So I will, speaking to the issue of Pascal's question regarding whether use-based versus registration may be better, and then subsequently to Karis's question as well. So I'll rephrase it as such. I'll ask you, since you were reflecting on the PAGO decision, and you had mentioned that the intrinsic view of trademarks actually seems to restrict the territorial grant, and that seems to be a descriptive conclusion of sorts. And perhaps then I'll address this as a normative question for you, rather than the normative things that judges may do. In terms of your work and the significance of this book-length project, would you go so far as making the normative claim that that judges ought to use the intrinsic value of trademarks to limit the territorial scope, particularly as Canada moves without the debate that we ought to have had on this issue, towards a much more further along the path of the registration-based system, not entirely, but further along that path. And to that, and then the second question I would add is, what then of, there seems to be some movement towards the recognition that junior marks or marks registered abroad may come to dominate in terms of the minds of the consumer, the meaning over a more senior local mark. And what then can we say about that kind of a scenario in which there may be no local trade by a trader, or the trader may be the user of a junior mark, and that the meaning has then come into some kind of tension or conflict with the registered in-use mark in a territory.
All right, now that's a lot there. Let me just, my notes are too scribbly. The first, or yes, to what extent normatively should we be cutting back on the political conception of territorial with reference to the intrinsic functions? I think the answer is normatively they should be taken into account. Whether you cut back to the only to serving what I'm calling for purposes of the intrinsic functions, I think would probably be taking it too far. So to give you again the example from DHL, and indeed PAGO, they were willing to cut back, but they started from the assumption that you had a default rule of EU-wide. It seems to me there is a legitimacy to the political agenda as well as what I'm calling the intrinsic agenda. So I would be willing, as long as they take them into account, I would be comfortable as a normative matter, not simply saying it's defined with intrinsic purposes. My answer, however, raises, I think, a really complex problem, which is broader than just a territorial project. Exactly what is the intrinsic purposes of trademark laws? I have assumed for purposes of this that largely those are sort of self-evident or apparent. But in fact, one of the problems that European courts have gone through, and that is very messy at the moment, is exactly what are the functions of marks, number one, and number two, even if they're more than source origin, do we protect them? And they've elided those two questions, the descriptive question and the normative question. So, for example, if in fact trademarks serve an investment function, essentially to get a return on money, rather like copyrights or patents, it's a normative question connected to the intrinsic function of marks and trademark law as to whether in fact that is something we should be worried about. So in fact, my answer in some respects is too simple because it conceals a lot of complexities of exactly what is the intrinsic function of mark. And I think we need to have an open debate about that. And the problem in Europe has been there was an attempt by the Commission to restrict the double identity cause of action to source origin, and the Parliament and Council reversed that. So we are having no changes in the current drafts of the regulation on that. So, so to pick your first one is that I just want them to be taken into account. What gets taken into account, I think, is actually quite a contested normative question, which I have lots of views, but it would be a different talk. On the final one, this is actually on well-known marks, which is basically, or foreign marks, is really the well-known mark doctrine to some extent that you're talking about. This is where I'm more pro-trademarks than probably most, which I actually think the well-known mark doctrine is something that is immensely vital as part of this broader picture. And the reason for that is it is something that is more closely tied to the intrinsic protection of goodwill. Now, you can be completely anarchic about that and say that any foreign use that's used online has some effect in Canada, and that sort of acquires rights. So there's real dangers. And what you saw in Gruppo Gigante was an attempt by the Ninth Circuit not to go down that anarchic route and to recognize there is still a difference between foreign use and local use. And I thought it was quite a good compromise to do that. But I think the idea of using the well-known mark doctrine is something that appeals to me because it's more closely tied to protection against a concrete harm than overbroad imposition of broad geographic rights. Okay.
All right. Well, it's time to say thank you to you.
Oh, pleasure.
So we have something.
Oh, thank you very much. Thank you,
from
Pina. Great, thank you.
Thank you for a stimulating presentation. So a big round of applause.
Thank you, Pina.
I know you have a plane to catch, so we look forward to welcoming you back when we see your work in print published, and also when our own system here, our own recent changes, have a chance to entrench themselves in our territory. So we'll look forward to hearing your comments on that.
Great.
So thank you so much.
Thank you for the invitation. Thank you for the lovely gift. I said this is already
Little
book reading.
Thanks. And thanks to all of you for coming and for your questions. We look forward to welcoming you back to our many events. I actually have a list of them, so if you want to take out your calendars and your phones to mark these down. On September 29, we have Dr. Emily Hudson, who's joining us from Oxford. And she'll be speaking on copyright exceptions as user rights, an empirical critique. So that's September 29. Then October 6th, we have Professor Jane Ginsberg from Columbia, and she'll be speaking on the Ariel decision and the making available right. And she asks the question, are we there yet? So that's a hot topic, so all hot topics. October 23 and 24, we're hosting an IP hackathon. And that's in large part inspired from some of my time on my sabbatical at Stanford, where hacking is more used in the lingo in the Bay Area, in the Silicon Valley, into hacking into a solution. And that's going to be looking at patents and the application process. And there we've paired up with the Canadian Intellectual Property Office, the Lassonde School of Engineering's BEST program, and Stanford University. So we'll have some able bodies from Stanford flying over to help us run this event. And of course, we end with a bang with Justice Marshall Rothstein from the Supreme Court of Canada. We haven't finalized his topic yet. Professor Wever, not yet, right? TBA, but no doubt meant to entertain, as he often does. So please do join us then. So that's November 24. And what I'd like to say is that this is, for me, IP Osgoode, and really a community is only as strong as its members, its speakers, those of you who attend. So please, I do encourage you to get involved, share your ideas, your thoughts, and things you'd like to see us do, and things you'd like to see on the website. So I'd encourage you to participate. Just a little housekeeping matter for those of you who are getting this, the Law Society credits, the CPD credits. Do see Michelle if you haven't received a certificate at the front. So see her when you exit. And so we look forward to hearing from you. Subscribe to the Epigram. We'll see you at the next event, and iposgoode.ca. The conversation will continue. So thank you so much, Professor Dinwoodie.